Hi, Arden Eby here, and today we're looking at natural law theory, the Nuremberg trials, and international justice. Hang on to your seats, we're going to be moving quickly. Okay, after World War II, the crimes and atrocities of the Nazis, such as the Holocaust and other events, were almost universally regarded as so evil that they absolutely required punishments. However, there was a problem, and the problem was that the actions of these perpetrators were perfectly legal under the laws of Nazi Germany. And even if we look outside the borders of Nazi Germany to Poland or the Soviet Union, where some of these atrocities were committed, the local laws simply were not made to deal with the scale of these atrocities. But states were sovereign. They had exclusive jurisdiction within their borders. So how could a trial like the IMT, the International Military Tribunal at Nuremberg, overcome this issue of sovereignty? The answer was natural law and universal jurisdiction. These concepts started to weaken the idea that states were absolutely sovereign and have allowed subsequent prosecutions of war crimes around the world to this day. Okay, so what is natural law? Natural law is a law which is created inherently by the nature of the universe and of humanity, the nature of humanity, which any human should be able to deduce from experience and observation regardless of culture. Where'd it come from? Well, on the religious side, that's the first place that we see it really fleshed out. And that's by Thomas Aquinas, writing in Summa Theologica in the 12th century. And he kind of fleshed out the idea that laws could be derived from nature, but then pointed out that nature is the creation of God, so this is really another form of God's law. But we're looking at secular natural law. Well, the ancients, like Plato and Aristotle, they used axioms of morality that they believed would be universally accepted, but they never fleshed out the concepts. For that, we have to go to the 17th century Netherlands and the work of Hugo Grotius, who was initially accepting of Aristotle's religious definition, but then clearly recognized that these laws could be deduced without reference to religion by anybody of any culture, any religion, or irreligion. This was accepted then by Thomas Hobbes, the 17th century English philosopher and tutor to the royal children, who accepted Grotius, but then proposed 19 specific natural laws that he derived from nature, specifically the nature of humanity, which he saw as being fundamentally the ability to reason, the ability to take experiences into memory and then apply them to reason, and also our social nature, which is our primary adaptation to a harsh world, also is creating natural laws of humanity. Well, there were alternatives, such as relativism, which is simply the concept that laws are just another manifestation of culture, like a food style, and that all cultures are equal, and therefore all manifestations of culture are neutral. But that means that the laws of Nazi Germany were simply manifestations of Nazi culture and really can't be judged as anything but neutral manifestations. And therefore, the atrocities of the Nazis that were almost universally recognized as evil could not be prosecuted. Well, another possibility might be positivism. Positivism was the commonly accepted view of law before the Nuremberg trials. And that simply states, when applied to law, that a law is a rule promulgated by a final authority in a state. And whether that be a religious leader, a text like the Constitution, a legislative body, a monarch, or what have you. So In this view, sovereignty is again absolute. And that does not solve the dilemma of how the Nazi atrocities could be prosecuted. So what was accepted was natural law as the basis for the Nuremberg trials. So there were alternatives, even beyond the range of law, and that was to simply take the perpetrators and shoot them. Both Winston Churchill and Henry Morgenthau, who's the U.S. Secretary of Treasury, proposed at various times simply shooting the leading Nazis. But that would have been perilously close to what the Nazis themselves did. They just took people they didn't like and shot them. So trials were seen as necessary. But of what kind of crimes? Well, we already mentioned crimes against peace, but crimes against humanity, the very name, taken from natural law theory and the nature of humanity itself. But how is jurisdiction to be exercised? Well, the trials presume that there is universal jurisdiction, that the laws of nature's natural law, are universal in scope, and therefore jurisdiction is equally universal, and they can be tried by anyone at any time. So they specifically refer to this in the Charter. I won't read the whole thing, but they implicitly reference natural law and then say, the very essence of the Charter is that individuals have international duties which transcend the national obligations of obedience imposed by the individual state. Universal jurisdiction. Okay, and again, crimes against humanity as a large class of crimes prosecuted indicate by their very nature the use of natural law theory, because the humanity being referenced is the nature of humanity itself. So this was well received. The United Nations adopted it into its foundational documents in Resolution 95 right after the trials. So we can say that this was a success. They were able to conduct the trials under the basis of natural law theory. But it was a limited success in that there was a long pause of 14 years before it was ever referenced again. And that was not until the Israelis kidnapped Adolf Eichmann, major Holocaust perpetrator, in Argentina over Argentine objections, took him to Israel, tried him under violations of natural law under universal jurisdiction. But then there's another even longer pause from 1960 to 1993. 1993 and 1994 saw some very serious incidents, including the genocide of Bosnian Muslims in Yugoslavia, and the genocide of Tutsi by the Hutus of Rwanda. And in both cases, the Security Council of the United Nations established ad hoc military tribunals to try the cases. But this prompted them to commission a study to determine if there should be a permanent international criminal court. Well, that court was chartered by the United Nations in 2001 and is still investigating and prosecuting criminals to this day. It has the challenge that many major states, including the United States, do not recognize its authority. And right now, the United States is under investigation for war crimes in Afghanistan. But the idea that those crimes, if they exist, will ever be punished is virtually nil, because the United States will not accept it. Still, there's a hope that the presence of the International Criminal Court will deter the worst possible outcomes that perpetrators might anticipate. Right now, it's being tested by potential crimes against humanity and genocide against the Muslim Uyghurs by China, and the Muslim Rohingya by Myanmar, aka Burma. But the hope is that the presence of the court will deter the worst possible outcomes. Thanks for watching. Eby out.